It's my pleasure as the Treasurer of the Law Society to welcome you to our Justice, Innovation and Community session, the kickoff event for Ontario's third annual Access to Justice Week. Je m'appelle Malcolm Mercer, le trésorier du barreau. C'est un plaisir de vous souhaiter le bienvenue aujourd'hui. I'd like to start by acknowledging that we are meeting on the traditional territory of the Mississaugas of the New Credit First Nation, and acknowledge the Haudenosaunee and the long history of all the First Nations in Ontario and the Métis and Inuit peoples. I say this in the spirit of reconciliation and the importance of reminding all of us that we share this land with one another and Indigenous peoples. This week is organized by TAG, the Action Group on Access to Justice, in partnership with over a dozen organizations. 5 years ago, TAG began as a Treasurer's Advisory Group. It has evolved since its creation, but it remains a catalyst for better coordination and collaboration to increase access to justice. With funding from the Law Foundation of Ontario, TAG works with a range of justice stakeholders to develop meaningful, public-centered solutions that seek to advance systemic change. Today and throughout Access to Justice Week, we are gathered to talk about access to justice and the role of the community. Together, we want to advance systemic change. The Law Society, which regulates Ontario's lawyers and paralegals, works to advance the rule of law and access to justice for the people of Ontario. We work to protect the public interest, which includes working collaboratively with our justice sector partners and the public to protect our justice system and promote access to justice. We have in Ontario and in Canada a remarkable justice system, one that is often emulated throughout the world, and often it should be emulated throughout the world. It is, however, a system that continues to present some challenges, especially the increasing number of citizens who try to navigate the court system on their own. Lawyers and paralegals have a critical role in facilitating access to justice. Lawyers and paralegals throughout the province provide legal advice to people so they can know their options when they have a legal issue. Lawyers and paralegals in private practice are helping those with limited means by providing services through legal aid, by offering reduced rates, or by offering services on a limited scope basis. My colleague Howard Goldblatt will talk more about that momentarily. Lawyers and paralegals also help through pro bono efforts through a number of important organizations, including some here today. Through the Law Society Referral Service, the Law Society has helped connect over 70,000 people to lawyers and paralegals who provide an initial consultation of up to 30 minutes free to help people determine their rights and options. The Law Society and the lawyers and paralegals that the Law Society regulates cannot solve the access to justice challenges alone. That's why we work with the government, the courts, Legal Aid Ontario, lawyers and paralegals in advocating for changes and improvements to how legal services are delivered in Ontario. The Law Society is pleased to facilitate this discussion and to explore current initiatives which directly impact the public. It's wonderful to have so many people joining us today in person and by webcast. It's an indication of the importance of initiatives like Access to Justice Week to advance conversations about issues at the forefront of justice. This morning's Justice, Innovation and Community session highlights the innovative, community-driven work from across the justice sector. We're grateful to the Community Legal Education Ontario, CLEO, Pro Bono Ontario, the Office of the Children's Lawyer, Hamilton Community Legal Clinic, University of Windsor, and York University for collaborating with us on this program. We look forward to learning the community-informed innovations each of these organizations has overseen in the realm of access to justice. I'd now like to introduce Howard. Howard Goldblatt is the co-chair of the Law Society's Access to Justice Committee, one of the leading benchers and contributors to the work of the Law Society. Join me in welcoming Howard.
Good morning, everyone, and apologize if I depart from my scripted remarks because I often do. Thank you, Malcolm, for the introduction. Apologize for perhaps correcting that I am actually the chair of the Access to Justice Committee, as I recall. No, it's fine. Malcolm called me the co-chair, but that's not a problem. I just want to assume whatever responsibility I can have and the power that I can wield. I am actually really grateful that Malcolm, as the treasurer, appointed me again as the chair of the Access to Justice Committee. This will be my third year as chair. It's a committee that I have served on almost continually since being first elected as a bencher, because it is a committee that I saw then and see now as playing an incredibly significant role in promoting the work of the Law Society, then of Upper Canada, now of Ontario, in promoting and improving access to justice for Ontarians, primarily through the work that we do within the Law Society, but because of our liaison and work with TAG, to do so much more broadly than just within our own jurisdiction. Well, I'm sure many of you are aware of the path that led to TAG and eventually to this Access to Justice Week, the third annual Access to Justice Week. Let me take a few minutes to review this history and how we came to where we are. So TAG, which is now called the Action Group, began at the Law Society as the Treasurer's Advisory Group on Access to Justice in 2013, and of course, once having adopted the acronym Treasurer's Advisory Group, we kind of got stuck with it and fond of it, and it evolved into the Action Group and kept the TAG nomenclature. I was very pleased to serve as the vice chair of that Treasurer's Advisory Group and to present to convocation in February of 2014 the report of the Treasurer's Advisory Group, which was unanimously accepted by convocation. And that made, formally, although it was certainly been part of our mandate, access to justice, one of the fundamental pillars of the work of the Law Society. TAG and the Access to Justice Group, as it now is, were both responsive to reports that were calling for more coordinated and collaborative action to address a growing access to justice crisis. In the Roadmap for Change report released by the National Action Committee, there is a key quote which I think is quite telling. Access to justice has often been thought of as access to courts and lawyers. However, we know that everyday legal problems mostly occur outside of formal justice structures. This underscores the view, and I think a very important view, that access to justice solutions need to be situated within our lived experience, not just the experience of lawyers and paralegals, but of the diverse population in Ontario who seek and need access to our justice system in a timely and appropriate manner. In 2014, the Treasurer's Advisory Group becomes the evolved into the Action Group on Access to Justice, and TAG then became a platform for justice sector organizations to explore collaboratively access to justice solutions. The Law Society served as a facilitator for the work of TAG, but was very much a part of the work, the collaborative work, the important collaborative work that TAG did. One of the first projects TAG launched was building connections between public legal education providers and public librarians, which turned out to be an incredibly important first initiative. This presented an opportunity to learn from those in the front lines about their take on access to justice, and a new way to start building a diverse network of advocates. The project brought together lawyers and librarians from across the province with a goal at creating new partnerships and new understandings. Librarians were provided with our assistance, and they provided us with insight into issues faced by their patrons, which including getting access to information, to government benefits, separation or divorce information, employment and wills issues, all of which have a legal component. The provision of information became paramount objective. Through this exercise, we learned that 83% of those participating in the project were eager to receive training that would help improve the access to justice for those who were their patrons, and they are working together with CLEO on implementation of that exercise. Another project which TAG helped to coordinate is Steps to Justice. The Steps to Justice website is a significant example of how collaboration can enhance access to justice for all. By facilitating a greater collaboration, TAG contributed to the development of this enhanced, reliable public legal information resource, which is already helping Ontarians to address their legal issues. Now, the last initiative I will highlight is the Law Society's own Family Law Action Plan, which seeks to improve justice for Ontario families. And you may well be aware that this plan was the Law Society's response to the Boncalo report, which made a number of recommendations on addressing the access to justice crisis in family law, and much of which was actually placed squarely within the jurisdiction of the Law Society. We recognize that there are significant unmet legal needs in family law. Many with family law issues don't know how to navigate our complex legal system and fill out the complex forms that are part of that system, as a very small example. And many experiencing a family law issue are required to appear in courts without legal representation for numerous reasons, and that in and of itself creates a crisis in access to justice. The Family Law Action Plan includes efforts to promote unbundling of legal services, a law a la carte, if you will, which we champion because it is one way to increase access to legal services for Ontarians. And in another way, which you may be aware, is that the Law Society is now very much involved in exploring licensing for paralegals and others to provide access and services to Ontarians beyond that which can now be provided. And we are well underway in that initiative. Approaching the justice system with a lens to increase access is beneficial for all Ontarians, our sector, and society as a whole. Which brings me to why we are here today. Access to justice is the most central and relevant challenge facing the broader legal community today. And let me say this, that we have heard and we have been talking about access to justice, the need to address the crisis in access to justice for years. And it is through the efforts of TAG, and it's through the efforts, I hope, of the Law Society and our Access to Justice Committee, and ultimately Convocation, that we can take concrete action, meaningful progress in addressing the access to justice crisis, starting, as I've identified, from our perspective, in unbundling and providing broader scope for representation by those who can't or don't want to be represented by lawyers. We must always work to ensure all people have the same advantages in our justice system, regardless of their identity or circumstances. Access to Justice Week is about bringing the issues of today into the public discourse, shedding the light on the challenges before us, and trying to obtain some common understandings of how we best proceed. It's not just enough to identify the issues. We must be proactive in initiating the conversation, bringing together people from all backgrounds and experiences, and finding meaningful, long-lasting solutions to the common problems that Ontarians face. Because engagement at any level moves the dial forward, I welcome this opportunity to engage in the coming dialogue. From research conducted by TAG in 2016, we know that 78% of Ontarians felt the justice system was old-fashioned. 70% said it was intimidating and confusing, while 4 in 10 said they don't believe they have equal and fair access to the system itself. Gaining more insight on this, we'll hear from two academics from the University of Windsor and York University who have delved even deeper into understanding how the Ontario's population's views of the justice system have evolved and their relationship to it. As a final note, I would look forward for a moment to the work on the horizon from TAG towards the 2019 Access to Justice Symposium. TAG is currently working to organize this symposium as recommended by the Law Society's Legal Aid Working Group and is part of TAG's activity plan. And when Malcolm established the committees, as is his responsibility as the treasurer, he gave a responsibility for both the Family Law Project and the implementation of the Legal Aid Working Group to the Access to Justice Committee, and we are working very hard in meeting the objectives that have been set for us by convocation. I'd like now to introduce Julie Matthews, the moderator for today's discussion, and I really mean this, a true Access to Justice champion. I've had the pleasure of working with Julie since, I hadn't met her before, but since the creation of TAG, and I was the Treasurer's liaison to TAG for a number of years, and Julie is certainly, to use the word champion, I think is a bit of an understatement, but she is a stalwart in the Access to Justice community. Formally, she's the executive director of CLEO, been the executive director since 1999, and her work in Access to Justice initiatives is extremely well known. Julie has been a hard worker with TAG. I trust she supports its missions and efforts, and I very much look forward to her moderation of this coming panel. So please give a warm welcome, I said me, to Julie Matthews. Thank you.
So that was way too much, Howard. Thank you very much. Anyway, so I'm just moderating. These are the people who are sharing with us today. So good morning, everyone. Bonjour. As ED at CLEO still, I am delighted to partner on this event with TAG to kick off this third annual Access to Justice Week. As Howard mentioned, I've been involved with TAG since its inception, and on many occasions I've seen the benefits of TAG and its work to encourage those of us who work in the justice system to collaborate and work together better. So, as Howard said, today we will hear from 6 people working on the front lines of access to justice, innovation, and community. Those 3 phrases, access to justice, innovation, and community, are some of the 3 of the most, I think, imprecise words in the English language, certainly not clear language. So suffice it to say that this is just a small sampling of the work that is being done by numerous organizations across the province to support greater and more equal participation in the justice system. So this will just give you a taste of what's happening. They are doing this innovative work by working with new partners, trying new ways to engage communities and trying to engage communities that have traditionally been left out, and using new research strategies to identify community needs. So as Howard said, we will hear from 2 research projects, 1 partnership initiative, 1 expansive new phone line legal assistance project, a project that serves to give a microphone to children's voices in the justice system, and 1 new website that isn't just another website. So a sampling, as I said. So to kick this off, I've asked each panelist to take a few minutes, and not more than about 3 or 4, to introduce their innovation or project. I'm a rigid timekeeper, but a nice one. But anyway, and after that, we hope to have more of a conversation, and I will ask the panelists a few questions that attempt to get at the nuggets of their work. So that's the plan for this morning. Towards the end, or at the end, we will invite you to ask questions of the panelists. So we will be giving you cue cards that you can write your questions on, and I guess this is for the purposes of the recording. You can write them on the cards, and then they will be brought up, and we will pose them to the panelists. So I think I was debating this, but I think I'll introduce the panelists one by one, because otherwise you might lose track of their great accomplishments before they speak. Okay, so the first panelist that and of course I don't have my 3rd page here for Lynn. So the first panelist is somebody who as well has been in the forefront of the access to justice movement for many years. Lynn Burns, the fourth to my left, Lynn over there, is the founding executive director of Pro Bono Ontario, an organization that develops and manages programs that connect volunteer lawyers with Ontarians who can't afford a lawyer. So some of Lynn's notable work includes creating a program to protect the education rights of children, launching Canada's first court-based self-help program for unrepresented litigants, creating Canada's first medical legal partnership, and launching the province-wide free legal advice hotline, the first of its kind in Canada, and it is going crazy. That's what Lynn's going to be speaking about today, is the free legal advice hotline. In 2017, Pro Bono Ontario served over 25,000 low-income Ontarians. So, Lynn, can you tell us a little bit about your project, please? You're gonna...
Trying to get this.
Okay.
Oh, there we go. Good morning, everyone. Can you hear me? Thanks very much, Julie, and I'm really pleased to be a part of this event today. I'm here to talk about how Pro Bono Ontario is leveraging state-of-the-art technology and volunteer lawyers to deliver services across the province of Ontario. We, for the past 17 years, have been embedding our services into frontline service environments so that our clients can find us, so that they can get help where they are. We are currently in 3 courthouses, 2 in Toronto and 1 in Ottawa. We're in 5 children's hospitals. We have a presence in each of those hospitals, helping families with their everyday legal issues and the crises that they face when they have a sick child. One of the challenges that we've been, sorry, this is getting ahead of me. One of the challenges that we've been facing, well, for several years now, is just we have a province-wide mandate, and we've been trying to provide services around the province. We had people driving in from all over Ontario to try to get legal advice at our court-based centers. So what we did was we tried to create a remote services line so that people could call us, we could put them on the phone with a lawyer, and get advice. The first year that we did this, we ended up getting 14,000 requests for services. And so, you know, despite our efforts to try to connect them with lawyers, we were only able to put probably about a third of these callers on the phone with a lawyer. So we realized that we were failing our clients. So what we did was, and we're always, every year we sit down, we try to figure out whether our strategies and workflow structure is working for our clients, and obviously this wasn't. So in 2017, September 2017, we launched our free legal advice hotline. And this slide just sort of shows the demand growing each year. But what we've done is we are using Salesforce as a platform, and we're using a variety of Salesforce-compatible technologies, and they all provide different functions. So the case management system and the knowledge management system are all provided through Salesforce. The knowledge management system has been really great. It's allowed us to develop a database of legal solutions to hundreds of legal problems, and this has been a huge support to our volunteer lawyers. We have a documents assembly program where lawyers on the phone can prepare court forms, various protection rights letters, powers of attorney, and the reporting that we're able to do using this new technology is amazing. And I'll get to that in a couple of minutes. We also changed our workflow structure, and I think it's working much better for the public. Now callers can dial our 800 number. It goes straight to a volunteer lawyer. The lawyer provides half an hour advice and makes a diagnosis and a treatment plan for the client on the phone. And it's going a long way in meeting the needs of people across the province. Where we had a few dots before, this new map shows that we're able to take calls from everywhere, and it's helping us get closer to our goal of trying to really provide a province-wide service. The other thing about this technology we're using is that it really helps us do a real-time legal needs assessment. And what we're finding is that we can tell, each day I get this report where I can see how many callers we got, how many each lawyer took, the consultations by area of law. We can even really drill down. For instance, if someone's asking us what kind of legal issues are seniors facing, we can drill down even further. What kind of consumer protection issues are seniors facing? So it's really giving us a very good idea of what the needs are out there and helps us better be able to address those. As you can see, our first year we served. In the first 12 months, we served 14,568 clients. And the remarkable thing about it is because we're able to do satisfaction surveys right as soon as we hang up, they get a text and they can rate the call and let us know if we were able to resolve their issue. But 81% of the calls are resolved with the half an hour of free legal advice and the brief services we provide. We've done more follow-up surveys. 95% said that our service improved their understanding of their rights and options. 97% said they understood the lawyer's advice and instructions. And 86% said they were able to use the documents that we helped them prepare and within 30 days. And 90% were satisfied with the service. Most of them were extremely satisfied with the service. So one last thing, and then I will wrap this up, is what's really made us understand the way people want to receive services. They want to be able to receive them in their homes, from their workplace, and that the other important thing is that 80+% can be of the legal issues can be resolved with brief services like that, and then the other 15 to 20% would be referred on for more services.
Thank you so much, Lynn. It's amazing. It's amazing. So needed project. Thank you. So second is Farah Wally, and she is a staff lawyer and project manager at CLEO, the organization that I'm at as well. Farah, you did not give us much of a bio, but in this complicated, demanding role, I stuck that in, Farah, she oversees the drafting and legal review of Steps to Justice content and basically coordinates the whole initiative, including maintaining relationships with our many partners and contributing organizations.
Thank you, Julie. So many of you are aware of CLEO, and as you know, we've been producing and disseminating legal information for over 40 years. Most of our information has traditionally been in print, and we focus on topics of concern to low-income and otherwise marginalized people. But we've moved more into online information in recent years, given that more and more people are going online for legal information, and they're expecting to find information that's more responsive and specific to their needs. So what we traditionally produced in print was a brief overview. And I mean, it was good to give an introduction into the area of law and the issues they were facing, but it did not give the kind of information people are now looking for, which is more action-oriented information, things that they can do to resolve their problem or just to better understand their problem and the things that they can do. So with so much legal information out there, we wanted to create a reliable brand that people could trust, and that was developed collaboratively by the major justice system stakeholders and community organizations that provide these services to people. So the great thing about Steps to Justice is that it is a true collaborative project. Across the various areas of law that we cover, we have over 70 participating organizations that have contributed to the content, either in helping structure the content in terms of coming up with the questions coming up with the questions that we should answer that people are facing, or even just doing the legal review of the content that we develop. So launched in January of 2017, Steps to Justice is meant to be an online, interactive, practical resource that provides step-by-step information on common legal problems that people face. So we do know it's for people with access to the internet and who have some sort of digital literacy skills, but it's also for the frontline workers that are helping them. So we do a lot of training to help these community organizations understand how to navigate through our site and to find the information that people are looking for. Looking at our website, sorry, I went too fast. There's 3 main ways of getting to the information. You can do a search through one of those search bars, or you can search by legal topic, which we have in the middle. And at the bottom of the screen, we try to phrase the problems that people may be having in more natural language. So, for example, they may understand more that I'm looking for help in child support. They might not know what area of law that they should look under. Oops. So if someone were to click on family law, they would be taken to this page, which lists the various subtopics that we have information. And if someone were to click on child support, you get a list of the questions that we have dealing with child support. We also have a filter that can filter the questions if you knew exactly what it was about child support that you were looking for. When you click on a particular question, this is what you get. It's an answer page. So the idea is that the person would read the answer to get a brief overview to the answer to their problem, and then on the left there are 3 to 5 next steps that you could click on to get more information on how you would address that issue that you're facing. When you click on a step, at the top there's a little navigation bar to kind of show you which step you're on and to let you know that there are more steps and information to read. Initial user testing showed that people weren't aware that our steps were clickable, so we're trying to make it clear that you need to click on the steps to get more information. Each step, we have something called a You May Need, which is a very practical resource to help people with that step. So it could be a court form, a checklist, a tip sheet. Again, it's something very practical to that step. So what we've tried to do is we've tried to pull in all the reliable resources that are out there. So it's not just Clio resources. It's materials produced by government, different organizations, legal clinics. We want it to be kind of a one-stop shop where all the reliable information is, so that people aren't searching around doing all these Google searches to find answers to their problems. A great thing about Steps to Justice is the ability to embed the content. So when we say embed, here is a great example of the Law Society's website, where they've embedded the various legal topics that we cover in Steps to Justice. So with embedding, you can actually have all the content on your website, and people on your website can search around without leaving the website. So everything opens within your own website. When the content's updated from our end, it flows through to the host site. So the host doesn't have to worry about creating content or updating it whenever there's a change to the law. We do that, and you automatically have that information at your fingertips. In terms of where we are with Steps to Justice, we have over 500 question and answer modules. We've soft launched a French version of the site. We soft launched in August, and we're working towards a more formal launch, which is coming soon. Another online project we're working on is Integrated Guided Pathways, which is an online fillable form assistant. So the idea here is you can find it on Steps to Justice. There's a little button, and it helps you complete the forms that you need in a family law case. So what you do is you answer a set of questions. The answers are taken, and they are populated into the various forms that you need. So there are different pathways depending on what type of forms you're filling out. So right now we've got 3 pathways that we've released: a joint divorce without corollary issues, a simple divorce, and filing a separation agreement. So you go through the pathways, the answers are populated in the forms, and then you get the forms which you can print out or save with instructions on how you can file it to the court, and with some plea associated with that in terms of other legal information you should be aware of. Thank you.
Yeah, thank you. Thank you, Farah. So next up, we have Professor Les Jacobs, who is a professor and director of the Institute for Social Research at York University. The Institute, for those of you who don't know it, is the largest university-based research center in Canada. They conduct, support, and publish social research with a particular focus on social problems, population and public health, mental health, and public affairs. So LES's past work has included research focused on legal problems in everyday life and growing economic inequality in Canada. He will speak about the Evolving Legal Services Research Project that he is conducting with CLEO. Thank you, Les.
Thanks very much. Thanks very much for the opportunity and also the opportunity to hear other people interesting projects. So the Evolving Legal Research Project has been going on for 4 years now, and it's actually more or less, we're now at the sort of final stage of it, focusing on basically analysis of data that we've collected. And the focus for the project is on everyday legal problems for Canadians around family, housing, and discrimination. And what we've done is we've been following for up to 3 years 425 people in Ontario and British Columbia as they've tried to deal with their problem. And specifically, we were thinking about a range of people using legal services, sort of scaled where at one extreme are people with full representation, and then on the other end, people who are completely on their own, with an understanding that in all of these three problem areas, most people are somewhere in between. They actually have some legal information, they have some assistance from non-lawyers, they have some assistance from lawyers, so there's a sort of scale. And what we really want to understand and focus on is how and when and for whom legal information was helpful, and in what form and with what other assistance. So as opposed to focusing on legal advice, it's focusing on legal information. And this question is, funnily enough, even though it seems like a pretty obvious question, there's virtually no empirical research really done on this about the impacts of legal information on helping people. In effect, because it's very hard to study. Unlike things like representation, where you can actually look at outcomes and so on and so forth and identify people who've been represented, legal information is typically things people access in a variety of ways. They don't track it well, and by its nature, in a lot of empirical legal research where we only focus at the end, we don't actually know where people have accessed legal information along the way. And so what this study did was design a pretty careful methodology, mixed method study, where we followed these people from the beginning of their problem roughly, and so we can track where they're using legal information, when, their sources, all those kinds of things. And of course, we get a good sense of what the process is, the nature of their journey, and of course, outcomes. And so what we're now at this point where we have a huge, rich, unique data set that can be mined to answer the key questions about the impact of legal information. And there's no doubt that the data set we now have is the largest, most detailed data set of its kind in Canada and around the area of legal information, quite likely in the US or the UK. Again, the US and the UK have no comparable studies either. And what another part of the methodology, because we wanted to try to really compare people's experiences, which is, again, a very tricky thing to do for all sorts of methodological reasons. And so what we developed at the beginning was an index that is organized around 3 pillars. One is what we call intensity of legal services. So in other words, we put everybody on a scale from 1, where 1 is that they had full representation in dealing with their problem, 10 where they were completely on their own, and again, scaled down where, say, a 5 is they had legal information, some assistance, but not with a lawyer, a 4, some assistance from a lawyer, for example, some kind of duty counsel advice or something, or phone legal advice or something like that, and so on. And the second pillar is that what we call quality of process. So in other words, what were their experiences on the course of them dealing with their legal problem? Did they get timely information? Did they know where to go? Did the process seem fair? Range of kind of considerations. And again, we scaled that on a scale between 1 and 5. What was also methodologically unique about this study is that we knew full well that participants or clients are not always actually the best judges of quality of their experiences. One of the reasons this is, again, difficult to study is for a lot of people, experiences with the justice system are a one-off experience. People don't typically go through many, many divorces or so on and so forth, right? Many housing evictions, so on, right? They tend to be one-off experience, so they're actually not always in the best position to judge. So we scored it from the participant's view, but we also scored every individual file from a experienced lawyer's perspective. And so we actually have had 4 lawyers, depending on the area, because family, housing, discrimination, and then family in BC, because there are about 125 of our participants there in British Columbia. So they assessed it professionally. So we actually have 2 scores about quality of process. And like the other third pillar is about outcome, so the quality of their outcome. And again, we have how the participants saw the outcome and then how the professional scored the outcome. Right? So we have this range of data, and the index allows us to basically score and compare every individual in the study and make comparisons so that we can look at, well, where does it make a difference? What if you were, say, scored a 5 on the legal intensity, so you had legal information plus some non-lawyer assistance, how are your quality of outcome and process comparable to somebody who had, for example, some legal representation, so basically an unbundled, provided, plus legal information, so on. So we can compare people across these ranges. So to just sort of give you sort of and I'll talk about it a bit later, and I'm going to run out of time very quickly. The outcomes are quite interesting. In effect, some of the outcome that's quite apparent is that the jump between people who have legal information on its own to having some kind of in-face or more personal assistance is huge. So there's a big effect or impact of combining legal information with some of that assistance. There's actually, interesting enough, not a whole lot of difference when it comes, when you go from non-lawyers to lawyers in terms of the assistance without representation. The data gets a little blurrier around representation. Here, for example, the difference between how participants score things and how professionals score things. For the most part, lawyers in their scoring actually will highlight that representation had a much bigger effect than participants. So there are lots of interesting data, and I'll talk about what it actually implies for sort of practical purposes in a moment.
Thank you, Les. Yep. A complicated project, hard to describe. Yes. So next up, we have Hugh Tai. And since Hugh was called to the Ontario Bar in '88, he has been a proud member of the community legal clinic system, and others, I think, join him in our pride. He is currently the ED of Hamilton Community Legal Clinic. He has practiced poverty law for many years in several areas of poverty law, and recently completed a 10-year appointment to the Health Professions Appeal and Review Board. So he says that his work life now feels a bit like semi-retirement. Hugh is a big advocate of inclusive justice and will be highlighting his clinic's work building on the Truth and Reconciliation Report. He is an aspiring settler ally.
Thank you very much, Julie. Just to point out, Ty has an E on the end. I'm going to talk about a 5-year-old Access to Justice initiative at our clinic, which is very collaborative in nature. We recognized at that time, and certainly members of our board of directors pointed out to us, that we were not providing access or a great deal of service to members of the Indigenous community. And there were all kinds of historical reasons why potential clients did not trust a non-Indigenous, government-funded justice organization. And so we knew that even though there was a large population of low-income Indigenous people in Hamilton and surrounding areas, we needed to do some work. So we based our approach on a sister legal clinics model in Sarnia, and we created an advisory committee made up of representatives of Indigenous organizations in Hamilton as well as members of the community. And then we hired an Indigenous justice coordinator who really, it's a permanent community development role and public legal education. His role is primarily to help us build relationships of trust with the Indigenous community. He meets with individuals in their homes, in coffee shops, he makes referrals, he supports them to obtain appropriate services, very often far outside the clinic. And he develops collaborative partnerships to do the systemic work that we do as part of our clinic mandate, so the community development, public legal education, and law reform. And Yondené is the initiative. That name was given to us by a member of the community. It's a Mohawk phrase which translates to "you and I will go there together." And we've taken many concrete steps to decolonize as an organization and how we approach service delivery. It's in a 2017 report called A Journey to Reconciliation, which is available on our website as a resource if you're interested. If you go to hamiltonjustice.ca, there's a page for Yondené, and the calls to action report is contained there. It's a great educational piece. It was very much a learning opportunity for us, and it's resulted in quite a transformation in how we deliver services. So we made changes to our reception. We were gifted a feather by the community. There are medicines available for use, such as smudging, if clients would feel comfortable doing that. We've made changes to our recruitment and hiring and our personnel policies. We have ongoing cultural competency training for staff and board. We declared National Aboriginal Day a holiday for staff at the clinic in order to participate in community events. And this model, as I mentioned, started in Sarnia. It is now in 5 communities in the southwest region of the legal clinic system. So that includes Legal Assistance Windsor, Kitchener-Waterloo, Elgin, Oxford, as well as Sarnia and Hamilton. So those are the logos for the 5 organizations. And usually the logos and the names come from community. It's very much a collaborative effort. And an example of a collaborative campaign that is a 2-parter. The first part was I Am Affected, which talks about intergenerational trauma, which largely targeted Indigenous people. The I'm Committed campaign is more for aspiring settler allies to commit to the calls to action from the Truth and Reconciliation Report. So if you go to iamcommitted.ca, there's an educational component and an opportunity to make commitments by signing on. So I'll stop there, Julie.
Thank you very much, Hugh. Yep. I'm always inspired by your clinic's work. Our 5th panelist is Professor Reem Body. Professor Body is an associate professor at Windsor Law, where she has helped develop and continues to teach a mandatory Access to Justice course for first-year law students. Wouldn't we all like to see that curriculum? Reem has a particular interest in access to justice for Arab and Muslim communities in Canada and was the 2017 recipient of the Guthrie Award from the Law Foundation of Ontario. Thank you, Reem.
Good morning. It's a pleasure to be here with you this morning. and to hear about all the important innovations that have taken place over the last several years within the profession and at the community level. When I first started teaching access to justice about 15 years ago, it was really hard to find material. And now the material and the developments are actually sometimes quite overwhelming. So I'm going to take away a lot from what I've learned this morning back to our classrooms at Windsor. But I'm here this morning to talk to you about an access to justice research project that I have the privilege of working on, along with the Arab Canadian Lawyers Association and with the support of the Law Foundation of Ontario. And this project really grew out of the fact that there is very little understanding of the Arab community in Ontario. We know from the last census that it's one of the fastest growing communities in the province. We also know that in certain areas like Windsor, Hamilton, Kitchener, Waterloo, London, and Ottawa, Arabic is actually the second most common language spoken at home after our official languages. But the Arab Canadian Lawyers Association would often get calls from either community groups or from public institutions asking about what are the access to justice experiences and needs of the Arab community. And the honest answer would have to be, we really don't know, because there has not been much research or consultation to find out what those needs are. So we partnered with the Arab Canadian Lawyers Association and, as I've said, with the support of the Law Foundation of Ontario, and we developed a 3-part project to help answer the question, what are the needs and what are the barriers? And that research project includes a mapping exercise where we look to see what would a person who had a legal problem find if they were trying to find resources that were directed towards their particular community. So how would they get to know what's available to them? Then we did interviews with Arab community organizations, and the largest aspect of our research is an online survey that we developed in consultation with about 15 community-based organizations and community leaders. It took us about a year to develop, partially because we thought we were ready to launch, and then we realized that what we actually had to do was make sure that our survey was available in both English and Arabic. So we stepped back in order to make sure that we were able to reach those parts of the community that actually don't have proficiency in English. We translated the survey into Arabic, and then we launched it online simultaneously in both languages. So our survey actually starts off with the theme that has been mentioned a couple of times today, and that is access to justice as lived experience. We didn't just want to know what are people's experiences once they get into the legal system. We also wanted to know, are there reasons why they might decide to not engage the legal system? And then are there circumstances where they actually have no choice? So when they come into contact with criminal law, for example. And we developed a number of scenarios that we asked
As an overview, the Office of the Children's Lawyer is an independent law office that is situated within the Ministry of the Attorney General. And our current children's lawyer for Ontario is Marian Jacko. Marian had worked for the children's lawyer for many years prior to becoming the children's lawyer for Ontario. She also worked with the Mother Risk Commission. And so the main mission of our office is to ensure that the personal and property rights and the interests of children in Ontario are protected. We have about 80 in-house staff. We're just up the street on University, and that includes clinical and legal supervisors as well as administrative staff and law clerks and whatnot. And so the OCL conducts we have approximately 800 clinicians and lawyers on our roster, on our legal and clinical panels. And they conduct custody and access, child protection, legal representation, and custody access and investigative services for the children of Ontario. And so the clinical department, the department that I manage, we are responsible for conducting Section 112 investigations, as well as participating in Section 89 representation, and this is under the Courts of Justice Act. And our department is responsible for the management of the Voice of the Child reports. And so what we call VOCs, as the acronym, is a service that started just this past summer. And what it does is that it offers a child to talk openly with a clinician in regards to specific issues of their custody and access case. And so the impetus or the reason for offering the Voice of the Child reports is because in the past few years there has been quite a push in terms of many legal professionals, clinicians, justices asking, when are you going to offer this service? The service is offered privately by many of the clinicians who are already on our roster. Jurisprudence has talked quite widely in terms of best interests, the importance of collecting the child's views and preferences in regards to determining the best interest for a child. We also have, in 2017, there was a research project that was done by Dr. Rachel Birnbaum and Professor Nicholas Bala in regards to the usefulness of these types of reports. And so some of the outcomes from this research project really talked about how much the children enjoyed being the only person interviewed, getting their views and preferences, not speaking to their parents. We also heard from justices, from clinicians, in terms of how useful it was in terms of settling the custody and access dispute. Voice of the child, views of the child, hear the child reports, they all come in different names, and they are being practiced in different jurisdictions. So British Columbia, New Brunswick, Nova Scotia, Manitoba, and now in Ontario. And of course, the main reason for offering this service is to increase access to justice for individuals who may not necessarily have the opportunity to be serviced by our office. So perhaps their custody access case is not as high conflict as the regular cases that we do have. And this is a way whereby if someone is having a small dispute in terms of what does the child want in regards to increasing overnight access or traveling, then they can access our office through the Voice of the Child reports. So some of the main points is that the VOCs are offered only in custody and access cases, so not in child protection. They must be requested by justice, and all parties are to agree that the child would participate in the process. They are done by clinicians only, so not by lawyers. It is done by clinicians on our roster. The child must be over the age of 7, although most of the referrals that we receive, the children are 10 and over. 2 interviews are conducted with the clinician in a private setting. There is some introductory conversation that the clinician would have with the parties in order to prepare the child to come in for the interviews, but the interviews are strictly done with the children. And then a summary of the interview is provided to the court, filed to the court, and the reports are filed within 30 days. So if I'm assigned a Voice of the Child report today on October 22nd, then before November 22nd, the report will be in the justice's hands as well as the parties. And so in closing, since July of 2018, our department has accepted nearly 100 Voice of the Child requests. And the requests are pretty equal in terms of OCJ and SCJ, with a heavier weight on OCJ requests. And about a third of our panel, so we have about 300 clinicians throughout the province of Ontario, so from Cornwall to Kenora to Toronto. So about a third of the panel are engaged in doing these assessments for the courts. It is a brand new service. It's only almost 4 months old. And we are constantly monitoring, assessing, making tweaks, and hopefully in about a year or so we'll be able to pull a lot of data in terms of the usefulness and other stats. Thank you.
So many amazing, interesting things happening, and thank you all panelists for sharing your experience and your thoughts on the work you've been doing. We are now, I have a few questions to ask of the panelists, sort of an attempt to have a sort of just an informal conversation. And as I said before, we welcome questions from the audience. For those attending in person, please feel free to jot down your comments, your questions on the cue cards. And we will be circulating to pick them up as they are completed. I guess just hold them up, Chloe, is that what they should do? Yeah. And for those tuning in via webcast, please submit questions through the webcast interface. So we'll dive into these hard questions. This is a question for everyone, and please keep your answers short just because I have a few questions I'd like to pose to you. So what was a key thing that you learned in developing or implementing your project that may be useful to others to hear about? I jumped over the one before that in case we run out of time. So this is the key thing you learned about. So Andrea, do you want to start with that?
Sure. So in terms of what we've learned in terms of developing and implementing this program is that the OCL partners with many different community groups, CLEO, and so with this particular program, one of the interesting things about it is that it really reaches out to the child and really takes those impressions from the child and brings it to the court. And I think that in terms of what was interesting for us was just how impactful a lot of the information and how much insight that a lot of the children do have in terms of the custody access situation. And we are seeing that they are helping to resolve some of these disputes in a rather quick way as opposed to months and months and years. So yeah, that would be my answer.
And Hugh, how about you going next, please?
I think a key learning for us was how woefully ignorant we were as non-Indigenous service providers about serving a complex community with a particular historical history. Reconciliation is a journey, and it starts with self-education. I think it's important for us to understand that history in order to serve clients. It's all about trust building, and as the name implies, Yondené, it's about walking that road together, and we've learned to do a lot more listening than talking, which for lawyers can be difficult.
That's great. Lynn?
I think for us what we've learned is, when I was talking earlier about really evaluating your strategies and your workflow structure to make sure it's working for your clients. One of the things that we were doing, we were spending a lot of time on intake and staff doing intake, and it was taking a long time to actually it was almost creating a bottleneck. So even though it seems counterintuitive for you to cut out the intake. We just find that our service is so much more efficient now than it was prior to doing that.
That's great. Thank you. Yeah. Reem.
Thank you. I've already mentioned the trust piece, so maybe I'll just talk about, I think, one of the biggest surprises for us was how deeply entrenched the idea of access to justice as access to a lawyer has been. And to try to explain to the people that we're trying to speak to that when we talk about access to justice, we're also trying to understand unmet legal needs as well, and that's important from a policy perspective to be able to develop good policy responses, but also from institutional strategic building perspectives to be able to respond to the people who don't use the legal system, so that we better understand why not and if that situation should change.
There are sort of two dimensions of stuff that we've learned. One is for sure that these kind of projects have to be collaborative, and they're complexly collaborative. And for academics, that's maybe a lesson that doesn't have to be repeated here in this room, but for academics, it's really important to emphasize that. Around the actual legal information, what became more and more clear was how complex the terrain was and how much change there has been. So as Farah said, a lot of Cleo's initial work, for example, was around print. And it's now very clear that most Canadians, when they're accessing legal information, are doing it in very, very different ways from how they were doing it 20 years ago. And that's both an opportunity and a new kind of challenge when we're trying to both understand this, but also understand the possibilities.
Farah.
Yeah, so one of the things we learned in developing and implementing the site was the challenges of creating a truly bilingual plea website. So our English content goes through a fairly rigorous process. One thing that I may not have made clear is that we make all of our content in very plain language. So we strive to write everything at about a grade 8 level. So we have teams of lawyers and editors who write the content, and it goes through various stages and back and forths to make sure it's legally accurate and it reflects the needs of what people are actually experiencing, and that it's easy to understand, because that's the whole point of accessible legal information. And then it's also legally reviewed to make sure that in the plain language process we haven't lost any of the legal accuracy. So then to get all that content up in French, it was a huge challenge because we wanted to do more than simple translations without starting from scratch, because it just would have been too much time and too expensive to do that. So we came up with sort of a compromise where we did a translation, but then we hired French editors to review the content to make sure it reflected the needs of the Francophone communities as well. So in terms of the language that we use, the terms, and so we would make adjustments that way. And even doing that, it still took a while, but I think it was a good compromise to be able to get that content up in both languages.
So the next question, I'm moving on in the order I had them. So, and this question is for Hugh, Lynn, Farah, and Andrea. So an observation that is sometimes made with respect to the justice sector and justice system writ large is that there are many players, institutions, and organizations, big and small, each trying to accomplish their own objectives in their own way, but with little coordination or sense of working towards a holistic vision of integrated justice services that people can find and access easily. How does your initiative fit or support other initiatives in the justice system? Who are you working with on your initiative, and who would you like to work with it in the future? So who wants to start on that one? Farah, would you like to start on that one?
So this project has actually been in the works for many years, and at the time it was in recognition of access to justice and family law. Many people are appearing in family courts without legal representation. So actually at the time there were many justice stakeholders who were looking to provide more family plea. And TAG was instrumental, as was mentioned earlier, in bringing together a lot of the institutions and organizations that wanted to create family law information, and then CLEO took the lead. But those organizations still contributed very heavily to our project. So in terms of family law, we have a steering committee that's made up of MAG, Legal Aid Ontario, the Superior Court, the Ontario Court of Justice, as well as TAG. And
legal clinics.
And legal clinics, obviously, yes, sorry. And so they've been very instrumental in helping us develop the questions that we should write about that are reflective of people's everyday needs and experiences, as well as reviewing the content. And Meg was very instrumental in translating the initial bunch of content that we had in family employment housing. We got more funding from the Law Foundation to do more translations of the family law content. And in terms of the content committees, we have over 70 participants. And for our Guided Pathways project, Meg has been playing a very key role in that, as well as TAG.
So anyone who's missing there, anyone you'd like to work with in the future?
I think as we develop more content, we're outreaching to the various organizations that are important in that area. So it's not only legal clinics or community clinics, it's also social agencies and services. So I think, I can't think of anyone off the top of my head, but as we write in other legal topics, we do outreach to the various networks out there.
Okay, thank you. And Andrea, do you want to speak to that one next, please?
So in regards to who we are working with in this initiative, the OCL is an independent law office, and so we're pretty much rolling out this program for ourselves. However, as I mentioned earlier, Dr. Birnbaum and Professor Nicholas Bala had been really instrumental in terms of the research that was done on these types of reports, and the OCL had partnered with them to give the administrative support. So the clinicians in that research project came from our panel. And so basically in terms of who would want to work with in the future, as I mentioned, there are other jurisdictions in Canada that are doing these types of reports, and we would definitely like to partner, reach out to these different jurisdictions and see exactly what's working for them, what's not working for them, what's working for us, what's not working for us, in order to better streamline the services.
Right. Mm-hmm. And Hugh, you said a little bit about this before, but we'd like to hear more from you, please.
Sure. I think a lot of our work is necessarily collaborative. In fact, I think it would be dangerous to do it by ourselves. Certainly in Hamilton, we're part of a large network of frontline Indigenous workers. An interesting project that we've become involved in with other legal clinics and the social justice cluster of tribunals is to introduce GLADU principles into administrative hearing process. So you're maybe familiar with GLADU in the criminal justice context, but we certainly recognized with many of our clients that it was completely relevant in the work that we were doing, for example, for Ontario Disability Support Program work before the Social Benefits Tribunal. We've met with the tribunal and talked about it takes a very holistic approach to determining disability, and so the GLADU principles are extremely relevant. So we've engaged a writer educator to help us work down that road. We've been involved in consultations with courthouses in our area with respect to establishing Indigenous courts. We're involved in an initiative at the University of Windsor. A professor and students are working on recommendations from the Ipperwash inquiry that have never been implemented. We met with the coroner's office just last week, actually, to talk about a particular case in Hamilton, but more broadly about barriers that Indigenous families experience with that part of the justice system. And we have on-site access points with the Hamilton Regional Indian Centre, the Aboriginal Health Centre locally. We do a lot of cultural competency training, and that's largely done by the Indigenous Justice Coordinator with our assistance. And we're also engaged in the health sector in various ways.
Thank you. Lynn.
I don't think I mentioned this, and if you're not familiar with Pro Bono Ontario, one of the things we did when we started in 2001 is we created guiding principles that we would not duplicate the work of legal aid, and we sort of carved out the area of civil non-family. I think what's probably missing in that area is a better continuum of services, and our hotline is only a year old, but Julie and I have talked in the past about at some point there should be the continuum from getting information to getting advice to getting representation. So I think that would be the goal of like the next phase for us.
That's great. Okay, so I have a different question for the two research projects. So another common observation, of course I say they're common, but mostly it's things I observe, but I think others do too, but is that much academic research happens in a relative vacuum and has little applicability in real life. In our context, that we lack space or breeding ground for findings to take up, that we lack space or breeding ground to take up research findings and build on them to improve civil society. How do you expect your research findings to be taken up and applied to improve access to justice in a meaningful way? Yeah, go ahead, Reem.
Thank you for that question. I will share with you that one of the sessions that I did to promote the survey and also talk about access to justice more broadly was at the Arab Community Center here in Toronto. And the first question I got from the audience was, is this research to benefit you or to benefit us? And then there was an apology. I'm sorry to ask you that question. And I said, don't apologize. That's the question you should ask every academic or every researcher who comes into this room. So let's have that conversation. And where we hope that the research that we're doing will have some impact is both within the profession to help raise some awareness, first of all, of the Arab community as it exists and what its needs are, but also outside of the profession with community-based organizations and some of the programming that they do. One of the things that I think will come out of this study that's not unique to this community, we've heard about it from other communities, is that access to justice isn't just about access to lawyers, and that there are other parts of our society that have an important role, librarians and healthcare providers, for example. So what we're really hoping is that this report will help to create some innovations that will not only expand the circle of those who are involved in access to justice delivery, but that will also increase understanding and equality for this particular community that we're focused on now.
Thanks. Let me just highlight three things that come to mind sort of immediately. One is, I didn't mention it, but our study has very detailed demographic. For people who don't know me, I do a lot of work on race, for example, and there's lots of and ethnicity and so on. And one of the interesting takeaways that Julie wouldn't know about, because we haven't even talked about it, is that in Ontario, there's been framed for the last 10 years or so a so-called middle-income access to justice problem, which is always framed as middle-income households can't afford lawyers. But actually what our data actually shows is that in fact there's middle income access to justice issues around legal information and its impact. So there's a trough, particularly, for example, in the family law areas where middle income groups who aren't who are accessing legal information in particular have less good quality of process, less good quality of outcome. And that's actually a bit of a surprise, and it doesn't correlate with race or with household income, or sorry, with education. So there's something interesting there, even about how it's being targeted, that's worth thinking about. The second is that, to a certain extent, the study reinforces something that intuitively lots of people, for example, folks at the Law Foundation have been thinking for a number of years, that this role of things like trusted intermediaries is really important, and you can actually understand now from our empirical research why they're important and how they're important and when they're important. And that actually, I suspect, will inform that some of those practices that are being unrolled. There's nobody here actually talking about trusted intermediaries, but probably many of you know that is an area. The third, for lawyers, the research actually gives a lot of instruction for thinking about developments around that, for example, unbundled legal services. Because again, that's in that wheelhouse of people combining legal information with other kinds of services without separate presentation. And probably many of you, when you see the statistics, for example, about what 58% of people in the family law review not being represented, and then you're kind of wondering, how did they group that? Right? I tried to dig into that. It's not clear at all. I mean, full representation. So, but there are interesting implications about trying to think about unbundled services. Those are sort of three pretty tangible real life implications in policy, practical policy.
Great, thank you. So the last question I'll pose of the panelists before throwing it open to you, or maybe you've been writing your questions like crazy, but what thoughts, and this is for everyone, what thoughts do you have on how your project can be boosted or picked up by others or adapted and multiplied? And it sort of crosses over to the question that you two just answered, but sort of, projects that last for a certain period of time and then sort of, just go away, or that are just confined to a particular community, or probably not as impactful. Is that a real word? Anyway, have as much impact as those that are sort of models that others can pick up and use in their communities. So that's the question. What thoughts do you have on your project can be boosted or picked up by others or adapted and multiplied? Reem, do you want to start on that one?
I guess two things come to mind. The first is that the survey that we developed, we'd be very happy if other communities wanted to pick up and work with it. What's unique about the survey, I think, from other things that have been done in the past, is that it adds the element of trustworthiness or institutional trustworthiness as one of the things that we're asking people about. And so what that presumes is not that people need to trust, but that institutions need to demonstrate that they are trustworthy. And then the other thing is that what we're hoping to do is have a meeting of community-based organizations to ask exactly this question. What is it that we can do as a research institution or researchers that will be helpful to you moving forward now that we've developed this one small starting point of trying to understand the community and its needs.
Great, thank you. So Lynn, we'll mix it up a bit.
One thing I've been thinking a lot about since we launched the hotline is, we're just providing services in civil, non-family, but it really is like the family law area could definitely use a program, a hotline as well. And, when people talk about the crisis of unrepresented litigants in the courts, if they didn't have to go to the courts to get legal information or help with their forms or legal advice, they would be at home calling someone. So I do think that there's a lot of room for growth with this model.
Yep. Great, thank you. Hugh, go ahead.
I think within the world that I am day-to-day, the legal clinic world, we're hoping that this can expand beyond the southwest region of the province. But I think on an individual basis, practitioners, lawyers and paralegals can embrace reconciliation and make personal commitments. And I think that's a self-education piece. If we're going to provide services to members of the community, we need to understand where they're coming from and what we need to do in order to meet them where they're at. And certainly trusted intermediaries are an important part of that.
Great, thank you.
I would say that for our program, it is newly launched, and as I mentioned earlier, a lot of the practitioners, mental health practitioners on our panel do conduct these types of reports in a private practice format. And so we are a bit late to the game, if you will, but at the same time, our format is different in comparison to some of the other private practitioners in terms of these types of reports. So in terms of what we would want to see is, I guess, a more cohesive way of doing these types of reports province-wide. And also the fact that our office, we do Section 112 reports. They take 90 days or more. They're quite all-encompassing with contacting different collateral sources and parties and whatnot. And then one of the things that we are also wanting to kind of rejuvenate and relaunch is what we call a focused children's lawyer report, whereby it doesn't take 90 days, it doesn't take 30 days as voice of the child, but 60 days, whereby the clinician would go out, interview the parties, the children, perhaps conduct an observation visit, and perhaps contact a relevant collateral to a particular situation, so that it basically what we're doing is we are reintroducing a format whereby we're having 3 different services targeted for the children of Ontario. And so that is something that, definitely we would want to see moving forward, and the justice system requesting and asking for these types of reports for different types of problematics.
Right, thank you. Vera, and then Lasia, go ahead.
So one of the important features and unique features of Steps to Justice is the ability to embed. And with the embed tool, we offer flexible options. So if you have a website, and embedding right now is only available to not-for-profit organizations and legal clinics. If you have a website, we offer the content in French or English, and then you can choose the type of content that you want. So if your clinic doesn't deal with all the areas of law that we have, you can select certain legal topics, you can even select certain subtopics, or even just single questions. And the way our embed tool works is that you can create multiple embed codes, which you can then put on your website, and we do offer technical support from our end. To date, we have 39 organizations that have embedded, and many organizations were waiting for the content to be available in French so that they can now go ahead and embed the French content that we have. We also offer trainings to those trusted intermediaries that Les mentioned. So if you are interested in training, again, you can contact us and we will come out and do that for you. And then also we have a social media presence. So we do have daily Facebook and Twitter posts, tweets, that you can also share through your channels as well.
Thank you, Vera. Les.
I'm sorry. On the issue really about how the project can be picked up, one of the biggest, a very big issue for someone like me who collects a lot of data on a lot of different issues is we collect data, we generate some reports. Academics will often produce books and journal articles that not many people read. And but in fact, this particular database is full of all sorts of information and correlations that, to a certain extent, me as a researcher or our research team can't actually anticipate very well. And I hold the first research chair in Canada on access to justice. And one of the things that I am doing with that chair is launching an access to justice lab that focuses on collaborative empirical research. And one of the thoughts I had was that it would be very instructive to actually take the data set into communities and actually just sort of have breakout kind of sessions where we can provide a team who can answer questions, run statistical software, so on and so forth. And literally most of this, we can do it on a laptop in 30 seconds. But it's actually getting the right questions from people and people who are practitioners and actually feed into that information. And that's an example of something that I think with this particular project has a lot of potential. And truthfully, we almost never see academics doing that. Again, because more broadly, certainly from my point of view, the data is not proprietary. It actually should be a public good that should be shared.
Thank you, pardon me. I know about this, but yeah, I like those ideas list, which we haven't discussed before. So that's it for my questions of the panelists, and thank you again very much for entertaining and responding in such thoughtful ways to my inquiries. And we did ask for questions from the audience, from the participants. And if you have a question for a particular participant, please note that, otherwise I'll just throw it out there. So the first question is for Lynn. So are paralegals currently involved in Pro Bono Ontario? And if not, is PBO open to including paralegals?
That's a very good question. We use paralegals on staff, and they are sort of like triage coordinators at our court-based centers, but they also answer the phone at the hotline and provide advice in the area of housing and small claims court questions. So we are using them. I have talked to a number of paralegals who are interested in volunteering, and we would love to have them at some point, but right now we have to work with the insurance carriers, and there's multiple ones. So until we get over that hurdle, we will not be able to. But is it Michelle? What's Michelle's last? Haig. Yeah, we met last year, and I think there's a lot of interest. But yeah, until we work on that, on working with the various carriers, I don't think that's going to happen.
Okay, and another question, I guess this is for whoever wants to take this one on. What are the opportunities for improving access to justice on environmental issues, given the focus on the best interests of the rights of the child and mental health issues and how climate change is likely to affect all of these? So opportunities for improving access to justice on environmental issues. Does anyone have thoughts on that really important question? Okay. Okay.
One of the, in the sort of broad disputing research, there's pretty standard distinction, idea about naming, blaming, and claiming. And that kind of way of framing things should be pretty familiar to most people who went to law school at some point. And most of the focus is actually on lawyers providing advice for people to move through those stages. But in fact, we know that only less than 20% of people, Canadians, actually ever get legal advice from lawyers when they have problems, including things like environmental concerns and problems. So the part of our study is actually about legal information, and a sort of hidden gem in the data is we actually now have data about how people use legal information to name, blame, and claim. And so if you think about, that environmental issues, trying to think about how legal information can actually be an effective instrument for pushing those claims forward. And that's happened in other countries. Japan is a pretty good example, where it's actually been very impactful around environmental claims, legal information as opposed to legal representation.
Yeah. And there are organizations such as the Canadian Environmental Law Association here that both works to advocate on environmental issues, and particularly those that affect lower income communities, and does a lot of work on the sort of legal information and public legal education front. So, yeah. Reen.
I'm just going to the question. I just wanted to observe that I don't know much, if anything, about environmental law, but what the question points to, I think, is how environmental law and environmental concerns more broadly are really integrated in the way in which we all live and in our futures, in ways that the institutions that we've developed really haven't contemplated yet. And so I actually think that the best response to that question was the almost uncomfortable silence that followed it. So I thank you for the question. I think it's something that I will be thinking about.
Anyone else want to take a stab at that? Okay, so the next one is the comment, and I think that I would, if any of the panelists want to speak to this, the comment that was made by one of the participants is certain things have to change before we can get true access to justice, a sentiment that I wholeheartedly agree with, and I think there's many things that have to change, but it's not for me, it's for the panelists. Do any of you want to speak about one or two critical things you think should change before we can get true access to justice? What's a big obstacle to getting there? Lynn?
I think what I would like to see is if there was some sort of access to justice commission. They do these in the states. Every state has had an access to justice commission where it's chaired by the Chief Justice. And they really get into sort of state planning, trying to build that continuum of services, coordinate things better. I also think that one of the guiding principles should be that everyone has a role to play. I think that the work that the private bar is doing is making a real dent in the access to justice crisis. And so I think that this needs to be at the table when there's talk about, having a coordinated access to justice system. I rarely ever see anyone from the private bar at any of these meetings, but they're doing a lot in this area. The other thing I would say is, the work that we're doing at Pro Bono Ontario is no less important than the work that's happening in the legal clinics. And I think it needs to be, we need to all make sure that these programs are sustainable. We're covering an area where there hasn't been any services before in the civil non-family area. And so I think it should be supported and brought in as part of the whole legal services delivery strategy.
Thank you, Lynn. Anyone else want to comment on sort of what things need to change, just one or two, before we can get true access to justice? Anyone else wanting to give thoughts on that?
I mean, as a non-lawyer, one of the things that the empirical research just consistently shows is that the siloing of legal problems from all of the other problems that Canadians have in their everyday lives is actually a problem with addressing those issues, kind of isolating the legal problems. And so this kind of, particularly for the legal profession, to see itself as embracing much more multidisciplinary responses to people's problems. That would be a big development. It's happened in other professions, probably most notably the health profession, and it's been slow getting sort of roots in the legal profession. I think there's lots of goodwill, and it's certainly not across the board that's the case, but seeing legal problems as not being separated. We still, even in legal education, certainly at Osgood, most of our students do just get a very narrow legal education, see practice that way, and so on. And it really doesn't reflect the lived experiences of people and how, particularly civil problems, right, but actually obviously criminal problems.
Okay. Anyone else? Okay, Sarah?
I know in the area of family law, there's been some discussion of more of a triage process because, as Les mentioned, it's not always just an isolated legal problem. Often there's multiple legal problems happening, and also sometimes there's not only a legal resolution to whatever people are experiencing. They just need access to other services out there, and they might not recognize that early on. So I think some way of having there be some person or some way for people to talk to someone early on to get that help or even that direction off to other areas where they can get other help, whether it be on their legal issues or other sort of social or mental problems, just so that people can recognize the issues that they're having and identify the different options that they have, especially where it might not necessarily always be going to court or going to a tribunal.
Thank you. Okay, and I only have one question here, so if anyone else, we have a few more minutes, if anyone wants to throw in a question, just fill out your cue card and we will, so I just have the next one. So the next question is, what role should dignity play in access to justice, especially in the outcomes, in administrative and judicial processes? So, I mean, I think that this question is getting at how do we better respect the dignity of participants in the justice system, and how that's reflected in the outcomes of courts and tribunal decisions. Any thoughts on that question about respecting the dignity of people? Lynn.
Because we've had a presence in the civil courts for going on 12 or 13 years, we know that a lot of the clients that we serve are not going to be successful in their cases, but we believe strongly that they deserve some meaningful access to justice. And, you know, and sometimes when you are talking to them after, just feeling heard, just feeling listened to, even if we can do an opinion letter that, you know, helps them understand that maybe it's not worth putting themselves through this whole ordeal to win. That's really important for their dignity. And so, like, you know, we don't look at it like, oh, this case has no merit, or, you know, we feel like they need to be heard, and that's what we try to do for them. Yeah.
Thank you.
Maybe I'll just echo much of what has just been said, that I think that's one of the biggest barriers to access to justice, is that people don't believe that they are going to achieve it, that it's a them and us, and they're not one of them. So in the work, just to highlight again, the work that we're doing serving Indigenous clients, dignity is the underlying foundation and starting point for engaging in a conversation. And I hear Lynn loud and clear that over the years, often clients have said to us, you're the first person who's listened to us. And so, you know, the outcome isn't quite as important as the dignity piece. And so it's very foundational.
Mm-hmm. And Andrea, thank you, Hugh.
I think coming from a cultural perspective, an anti-oppressive perspective, it's extremely important for individuals to be heard for their whole cultural makeup and lived experience and, you know, socioeconomic background, all of those things to be considered when interfacing with the legal system. I think many individuals feel that justice system is an oppressive system, and so to be heard, to be understood, for us, it's important to have lawyers and clinicians who are well-versed in anti-oppressive practices and who are willing to learn about different cultures and different identities. So,
thank you. Okay, so another question. How do we address racism, colonialism, and anti-poor bias among judges and tribunal members? Isn't that the biggest barrier to access to justice? Okay, so everyone, it looks like Minnie might have something to say, so let's go ahead. Yeah.
One of the odd phenomena in Ontario, arguably in Canada, but in Ontario, is that there was a history of not collecting race data in the justice system, but more broadly, not just in the justice system. And that made it actually very difficult for substantiating claims like racial profiling and other instances of oppression. And so the shift, I mean, the Ontario government adopted the Anti-Racism Act in 2017, and part of that act is race data standard. So we now have an Ontario race data standard, which will eventually trickle through the justice system. So we'll begin to actually have data unless we have data, and that's where we actually see some changes. And I speak as somebody who both played a pretty big role in the establishment of the race data standard, but also in a number of racial profiling studies. And it's clear that getting those numbers out there actually brings about some change, and you can already see it in some of the police services, for example, that are beginning to trick through, and the police services that haven't collected race data are actually arguably the ones who are least progressive.
Right. Reem, please. Yeah, thanks, Les.
Sure, where to start? Boy. So data's great. It's important. However, I worry that the requirement to have statistics, leaving aside how they're gathered and interpreted, is itself an access to justice barrier. Those groups, those organizations that can gather the data are the ones that will be seen, be understood, be heard. Case law and judicial decision-making is not the same as social science evidence or social science data. It doesn't need to be treated that way. And in my own area of research, when I look at the case law and I ask a very simple question, has this judge or has this decision maker recognized a basic stereotype? Not saying have they decided in favor of the complainant or the respondent or the plaintiff. Have they just recognized a stereotype? The answer is more often than not, no, they have not. And I think it goes to Hugh's point about you can't judge, you can't provide justice if you don't understand. And so I absolutely agree that colonialism, racism, these are things that we still haven't fully grappled with in the legal system. And sometimes we think of access to justice, even though we say we don't, we always come back to access into the court system as a form of dispute resolution or the legal system. And we don't realize, I think we've actually, of course we realize we've sidelined the way in which people get understood and treated within that system. And so when I think about access to justice, I really hope that we don't forget about those issues in our quest to understand the access part.
Mm-hmm. Thank you. Anyone else on this important question? Did you want to say something?
I guess I've touched on this before, but the education piece starts with the service providers. I think it's the education piece is necessary for judiciary and all of the other stakeholders, and certainly in one of the calls to action in the TRC report is about education. So it's about institutional education, but it's also very much an individual education. And I agree with Andrea that the anti-racism, anti-oppression lens is critical in everything that we do. I know that how we deliver services in our clinic has changed dramatically in 20 years because we are using an ARAO lens, and we're now looking at communities as having distinct historic barriers, and that we need to respond individually to those communities in order to truly provide access to justice.
Thank you. Okay, well, I think we will wrap up just about on time, and I would like to thank all of you for your interest and your willingness to come today and listen to this panelist and engage with them and ask your questions. And thank you to the Law Society and the Action Group on Access to Justice sort of for organizing and hosting this event. And last but not least, thank you to Farah, Andrea, Hugh, Lynn, Reem, and Les for coming today and sharing their thoughts and experiences. And I've been told that if you have a little bit of, if you have a little hunger in your belly, there may be a lot of food back there.